Hello, everyone. Derek Johnson with Tatango.com. I'm here with Joe Bowser from Innovista Law, home of the TCPA Defense Force. And today we are doing a TCPA case review where we look at an existing TCPA text message marketing case and we dissect it, look at what happened, and then most importantly, what text message marketers can learn from what happened in that case. How you doing, Joe?
I'm doing well, Derek. How's it going?
Everything's good. So today, the case that we're going to review, and I most of the time I butcher these names, especially the plaintiff. The plaintiff is the person that is usually first in these lawsuits, and usually it's their last name, so it's the hardest. So I'm going to say it. It's Warciak. Again, I'm guessing, and if I'm completely right or completely wrong, let me know in the comments. But it's spelled Warciak, verse Nikil. I'm guessing that's how, and this is a corporation that this consumer is suing, and it's Nikil. And essentially, they're the ones that are behind the Down to Lunch app, which is essentially an app, from what I can tell, is essentially an app that connects people that are down to network. So I guess you could kind of think like a grinder for networking, I guess. I don't know. That's kind of the only thing that came to mind, or Tinder, I guess. I guess grinder or Tinder. It seems a little more kind of raunchy, the down to lunch type thing. So
this one seems to be on the up and up. It's a daytime app.
Yeah. Okay. That's good. Only daytime stuff. So this consumer, they are suing. Let's just call it Down to Lunch app, but they're suing the company behind it, which is common. That a lot of companies have like a holding company. So this Nikil Inc. essentially owns the brand Down to Lunch, and that's similar with companies like even Tinder is owned by another company. And
Innovista Law has the TCPA Defense Force, right?
Yep.
You can have a brand.
Yep, exactly. They just operate under that brand. So for now on, I'm going to just call it Down to Lunch because I know how to say that. Okay. So Down to Lunch created this app, and the app's purpose, and I'm reading from this website here, is to connect friends to allow them to easily and spontaneously meet in person for events and activities such as meeting for lunch. Sorry, I was wrong. I was thinking this was lunch meetings, and I was like, I guess I'm so into business like that. So this is literally like a Tinder, Grindr, OkCupid, but it's for friends, and it seems like it's for friends that you already know. I was thinking this was more like a networking app, like, hey, if you're interested in networking, let's go grab some lunch. But it seems like this is more of your friends are looking for things to do, and when maybe you're available for lunch, you could see who else is available and message them and connect and essentially meet for lunch.
It's to make you stop putting your head down, walking to Potbelly's, grabbing a sandwich, and going back to your desk.
Yeah. Hopefully you read this, because I bet you were like, what is he talking about originally? As I'm trying to read through these cases here. So
you're close.
Okay. I guess close enough. Down to Lunch. Okay. So this consumer, Warciak, alleges that, so it's a he, received a text message from Down to Lunch, the app, stating that one of his friends had invited him to join the Down to Lunch app, and it was an invitation text message. So this consumer received a text message from the app that was essentially like, hey, come join me on this app. And we've seen this many times before. I look at it as kind of like a growth hacking type thing for mobile apps. Essentially, use your existing users to invite new users. And this used to be done via email. Then it was switched to Facebook. And now it looks like a lot of apps, because of the open rate of text messaging, 99% open, and then 90% open within 3 minutes. They're moving away from email, which has very low open rates, and Facebook is definitely locking down its platform. They're moving to text messaging. So we continue to see these kind of companies, kind of growth hacking using text messaging.
Well, and it comes with the advantage of having your friend make the introduction rather than the app bombarding your phone.
Exactly. Now, it looks like, so in this case, he says the plaintiff alleges that Down to Lunch users are not aware that by using the app to send invitations, they cause a text message to be sent to recipients like this person, and that Down to Lunch was actually responsible for generating the text messages. This is what the plaintiff claimed.
Correct.
So what he's claiming is that his friend maybe clicked like invite friends or something, but the plaintiff doesn't think that his friend actually realized that when he clicked that, it would send a text message to all his friends, essentially inviting them to the app. Am I getting to kind of the base of the lawsuit here?
Those are his allegations. Whether or not it's true that someone using the Down to Lunch app really would be clueless about whether a text message or an email would be sent remains to be seen. Obviously, you and I can download it and see what the experience is like ourselves. But because this is a motion to dismiss, the court has to take the plaintiff's allegations as true.
Okay, and explain. So this was a lawsuit brought by this person,
federal court.
Okay, brought by this person against this company,
Yep.
And then the company said essentially like, no, we're going to try to get it dismissed. They'll file a motion to dismiss, right?
Right. A motion to dismiss is one of the first things that a defendant can file, and it's basically an early attack on the legal adequacy of the complaint. So what the court is expected to do is to basically say, plaintiff, even if everything you say in your complaint is true, do you still lose as a matter of law? Right? Okay. Because what the Down to Lunch app makers were saying here was, I don't care what he says. Like, let's just pretend like what he's saying is true. He didn't know that the user didn't know that a text message would be sent. Even if everything he's saying is right, I'm not the initiator of the message. It's your friend who initiated the message, and that's what matters for purposes of TCPA liability. So this is a case that's about the question of who initiated the message.
Okay, so this consumer is essentially saying, this defendant, the brand Down to Lunch, they're saying essentially to the judge, they're suing the wrong person. They're not saying that, but they're saying essentially, we are not responsible for this message because the person, the friend, was the one that actually text messaged them. Therefore, not our problem, and he's welcome to go sue his friend if he wants, but this is not our responsibility because the friend initiated the text message by clicking or doing something in the app.
Correct. Right. They're saying that regardless of whether there's responsibility elsewhere, it's not on my lap.
Okay. So they asked the judge in a motion to dismiss. They said, hey, based on exactly what the plaintiff is telling us in the court case, he explained everything to them. Based on that, based on the law, there's no even reason to take this to a jury because there's no law that was broken against, Down to Lunch. So you got to throw it out.
Right. And fortunately here, the federal district court in Chicago had the benefit of two FCC opinions about how text messages that are sent via an application or in an application context can or cannot violate the TCPA as it relates to the app maker. So there's the Text Me case, which is the one you would want to follow if you don't want to be liable for TCPA violations. And then there's the so-called Glide case, which is the textbook example of how you essentially hijack the user's phone and send messages without the user's participation or consent. So the court had the two goalposts here and said, are you more like Text Me or are you more like Glide?
But it does seem like, and maybe this was just kind of, smart on the plaintiff's attorney's side, is it does seem, as I was reading it, that he was kind of alleging that, his friend didn't know that, he was inviting his friends. So what is the difference between like Glide, which kind of hijacked essentially, that's what the court figured out, the contact book of the users, compared to this one? What was he, does it seem like he was trying to, push them towards one way or the other? Like did they know about these two cases?
Well, the court did take up that question, and it basically reasoned that it doesn't matter whether the user knew how it was going to get sent. If the user was reckless in not knowing whether the text message would be sent, that's a fight between Mr. Warciak and his friend, right?
Okay.
But all I need to know today is, can I hold Nikil Inc. liable, Nikil, for this message, right? So that initiator analysis is independent of whether this plaintiff understood the nuances of which technology would be used. So as the court reasoned, it basically said, like, everything we send involves fairly sophisticated amounts of technology. Just because you don't know how your phone actually gets the call from your wireless device to the tower, to the cell site backhaul facilities, back to the switching station, and then off to the public switch telephone network, just because you don't understand that as a consumer doesn't affect the liability, right? So the key legal question was whether the Down to Lunch app maker was the initiator, and whether the plaintiff's friend understood the nuances of which technology would be used was beside the point.
Okay. And I'm not very familiar with the Glide app and the TCPA case for that. Essentially for that one, was Glide literally like scraping all the phone numbers without even the consumer clicking invite friends? Like, well, I guess, where was that difference there?
Right. So that was a key difference. Glide did not allow the user of its app to have any participation in whether Glide would send the message. So in the Glide case, Glide decided who got it, what the message said, whether a message was sent, and when it would be sent. Now, in the Text Me case, Text Me, and this is also true in this case, in the Down to Lunch app, Down to Lunch essentially constructed the message that the user would send. But in this case, the user got to go through their contact list and decide whether they would skip or invite any particular person on, in their contact list.
Okay. That's the Text Me case?
That's the Text Me case and this case.
Okay. So there was human intervention there. Like, it didn't just do it automatically when you download the app, which is kind of more the Glide scenario. This is now, and I guess there's varying degrees on, is it automatically select all your friends? Do you select your friends? But it is more of a manual process for one of the users to go through to then initiate the message. And the court has been saying for, a few cases now that, and what are those qualifications if it's you decide what to send, when to send, and who to send it to? Essentially,
so even the what is an open question, right?
Okay,
So Text Me was deciding what the message would say. In this case, Down to Lunch was deciding how the message would read, probably so that they could keep it within the 160 characters and make sure they'll link to the app.
And they know what converts too. So
exactly.
Yeah,
so
okay.
They had a hand in the content of the message, but the key questions are whether to send a message, to whom to send the message, and then when the message gets sent. So in this case, the user did get to say, you know what, I'm going to do this tomorrow. I'm not going to do this at all. I'm going to skip this process of inviting my friends to download the app. Maybe I'll tell them the next time at lunch or whatever. Right. So the Down to Lunch app user had total control over whether anybody got any of these messages, and whether they thought it was an email or a text message. The court didn't care, because at the end of the day, the user was the one deciding whether to send it to any given contact, when to send it, and who got it. Now, we talked about the Poshmark case before, and there was a button where it was invite one or invite all, right? And it's not even clear from this case whether there was even an invite all option. Okay.
But either or, it's the consumer that was using the app was the one that was making all the decisions.
Correct.
And you see the same with text message marketing software providers like Tatango, where, we provide software, but then, our clients, our brands that use the software are the ones that decide essentially everything, besides how the software is built. And, they decide what they're sending, when they're sending, who they're sending to. They can segment their messages. They can include an image, not an image. So on ours, we're meeting all the person using the platform is meeting all those qualifications. We have no hand, in helping them with that. So do you see kind of this going across and applying to, apps and software providers and even like aggregators and carriers, like everybody that essentially is part of the process, but really has no say in what is actually being sent and when it's being sent and to who.
Yeah, no, the initiator question has broad application to the TCPA cases, right? Because there are a number of TCPA issues that relate to how many different defendants can we hold responsible for any given campaign. And so you look to the level of human intervention that any one of them had. You look to the extent to which person A has hired person B or company B to act on its behalf. In those cases, both of you can be the initiator if you've essentially delegated the task of initiating messages to a third party. But if the person who is providing the technology, or in your case, the platform, to facilitate the delivery of messages, then courts are pretty comfortable saying, that's not the guy. Okay. That's not the company that Congress meant to hold responsible for those decisions.
And this is why you very rarely see, SMS aggregators being brought into these TCPA lawsuits, or,
I wish it was less frequent. Some of the plaintiffs' attorneys still, are in the habit of naming them in cases. Okay. But once we show that our platform provider clients, didn't have the requisite level of involvement in the campaign, then we can usually pretty quickly get them out. But yeah, and you've got to be careful. Sometimes platform providers can straddle that technology provider hat with, am I really an adjunct to the marketing team, and am I providing consulting services essentially for how best to architect a campaign? And so you'll see some plaintiffs taking website copy and things like that and arguing that a platform provider really is an arm of the brand that's using the technology.
Like more than just providing, the login and essentially them, clicking send. They're providing, hey, you should change the message and you should send it here, and providing more than just the software.
Right. And obviously platform providers can and should educate their consumers on CTIA issues, right? Like just like the car manufacturer puts the user manual in the glove box. Yeah. Platform providers shouldn't be responsible for providing tools for success. That doesn't mean that you, the platform provider, is accepting responsibility for how they use the tool. But if you go above and beyond that and you provide actual marketing services, then I think platform providers and the brand should know, okay, maybe the lines are blurring a little bit.
And this is the same with like marketing agencies that may help a brand that may use a software. So there, could be, it's not always so black and white essentially where one's responsible or not. There may be multiple people that are helping send the message or, crafting the message. So it is something to think about, when doing text message marketing, figure out kind of who is involved and who's responsible, because at the end of the day, you could have one of these TCPA lawsuits and, you should have thought about it before rather than kind of thinking about it later.
Right.
Okay. Now these apps, it seems like we've done a couple cases similar to this. It seems like now, is this a okay thing for apps to do? Like it seems like the use case of, selecting your friends and clicking, send. It seems like, there's been a couple cases where it's been thrown out, of court. Mm-hmm. When do you think we'll stop seeing lawsuits similar to this? And when do you think brands will start feeling a little more comfortable that, this kind of tactic is no longer kind of a huge risk, like I guess it was, a year ago?
I'd probably be living in Vegas if I told you that I could predict when the lawsuits would stop.
Okay.
But I do think that this is not a fertile area for the plaintiff's bar anymore. I think the law is reasonably clear about how app providers should architect the user experience in terms of distributing, facilitated text messages to the user's contacts. I think you want to put as much of the decision-making power in the hands of the user. And I do think that it's reasonably safe within certain parameters to facilitate the content of the message, just to make sure that, you have a good experience. Yeah. With what's being
not put the link in or something like, and then your friends are like, what the heck? Like, I want to join, but I don't even know how to join.
Exactly. Right. So yeah, you want to make sure that you have a quality experience for the people who are first being introduced to your tool, right? But I don't see a lot more of these cases coming through, in part because I think that the courts are pretty clearly applying the text me and glide rulings pretty clearly.
Okay. Is this something where if you're an app builder, manufacturer, whatever, is this something where they should be coming to a TCPA attorney if they're thinking about kind of doing some text invite functionality before, like even during, the build and the design, the UX, UI kind of process, they should be including you guys rather than maybe just showing you the app at the end, or even worse, coming to you after they've been sued. It seems like right at the drawing board stage for these apps, they should be bringing you in to kind of, because, these growth hacking techniques really work. Right. And there's obviously a risk for every growth hacking technique, it seems like nowadays. I think that's a just a discussion that the company needs to have. Mm-hmm. And I think the only way you can have that is by including a TCPA attorney. Do you jump in like to kind of whiteboard sessions with companies and figure out like, okay, here's the risk, if you go this way or that way, and we can make it a little less risky if, you do this, this, and this?
Yeah, absolutely. We whiteboard, we work through mock-ups, and, ideally we get in on the front end, as you said, because you don't want your engineering team to get down the path and then they have to rebuild pieces of the program and the user experience, redo things. Yeah. So that and then you're delayed to market. So ideally we get in up front, we get involved and make sure that things are architected correctly the first time to minimize the risk, but then also improve the user experience, because frankly, a lot of the TCPA compliance issues marry up with the goal of giving, an enriching consumer experience that kind of respects their privacy, lets them opt out when they want to opt out. And then in the app side, gives the app users the opportunity to choose who gets the message. And it's not, that they feel in control.
Okay. And you guys only work on the defense side, right? Like, so the brand side.
Brand or platform provider side.
Okay. Because I've heard, and maybe this is just weird, but I've heard some people, they're like, oh, I don't know if I want to go and express my concerns, or maybe where we have holes, because, then they may look at it and go, oh, that's a great, lawsuit for a consumer to bring. You guys only focus on the brand. So you're not like playing both sides of the field. I don't even know if people do that, but I've heard that as a concern.
Well, there would obviously be ethical issues if an attorney-client, relationship was created and then you used that information to do anything with it adverse to that client. So
it shouldn't be a concern. And especially just going to a TCPA defense kind of, I guess that's maybe why you named your, company that.
Well, the firm's name is Innovista, but the practice group brand is TCPA Defense Force.
Okay. So, and you guys aren't like, and I've heard this too, you aren't there to like, crush ideas and like, make it really, really hard to, implement growth tactics. You're essentially there to look at it and then say, kind of evaluate the risk. And if the company wants to push boundaries, and even maybe create case law, that's something you can tell them, but you're not going to be there just being like, no, 100% you can't do that. You're working with the brand. And I've seen this with some brands you've worked with, where you're tweaking things and you're kind of helping them along the path. Because I think a lot of marketers are just, man, if we go to our TCPA attorney, this whole thing is going to be shut down.
Yeah,
like, I guess in some cases maybe that happens, but it seems like in the majority of it, you're just like, well, you can't do that, but you can do this,
Right. There are a handful of no's in the TCPA space, but there are plenty of yes ifs. And so we steer our clients in that acceptable range of outcomes where there may be more or less risk for any given choice. And we'll explain to you what that is, but there are plenty of ways to do this right.
Okay. So it seems like from learnings from this perspective, it's good that we're having multiple cases, thrown out. It's good that we have kind of the spectrum, which is, the glide, where it's like, hey, I had no clue that by downloading this app, they would text message all my friends. Right. And then on the very other side is I selected each friend and, I create the message and I click send. So it kind of has set, I think, the goalposts for, acceptable and not acceptable. Right. And then I think there's kind of that middle ground. Is there anything else that, we've learned from this case, or is it essentially that we're just moving in the right direction and really creating good case law?
Well, I think the case is also important for the broader industry so that we all know and have a clear expectation of who the initiator of a call is. Because sure, it is helpful to see for app providers, but it's also helpful for other applications when we're deciding, who's really hitting send here. And so when you build those use cases, we all have a clearer idea of where the risks lie and where, we really want to make sure that it's one thing to put a risk in a certain place, but if we're also going to get ourselves implicated in that risk, do we feel like that person is capable of defending and indemnifying us if we're really giving them more control over something, but we're both jointly liable, right? Like that's part of the risk analysis that we do is if we're going to share the risk, but the person we're sharing it with isn't likely to absorb any TCPA exposure, which can be significant. Is that a business decision that we want to make?
Okay. Now, does this like the fact that these cases are going to court but then being thrown out by a court, does that help, future, I guess, cases? Like do attorneys cite essentially, 15 and then 50 and 100 cases by saying, hey, in all of these cases, that is not the sender. Does every single case that gets kind of thrown out or, ruled in favor of the business, does that just make it better and better for software providers and app makers in the future?
Yeah, it's another brick in the wall, right? This particular decision from the federal court in Chicago isn't binding even on itself. So until you get a case that rises to the level of the circuit courts of appeal, and even then, those circuit decisions only bind the trial courts that are within their jurisdiction. So until you get something to the Supreme Court, you don't really have the law of the land, as it were. But this is another case in this line of TCPA issues where the path is pretty clear, and so we feel like the law is getting fairly settled in this area, and so we feel more comfortable recommending a certain course of action and avoiding others.
So when these cases get thrown out of court, that doesn't actually create a new law. It essentially just allows defense attorneys to kind of reference that for future lawsuits and future discussions where they can say, well, in these 7 cases, this is what happened. But the only way it becomes like a law where it's like, hey, app makers can do this is when it goes to the very, very top, right? And then,
well, either the FCC issues a ruling that isn't appealed in time or is affirmed on appeal, or the Supreme Court ratifies a certain ruling, affirms a certain ruling. So it is difficult to get something that you can take to the bank without any risk.
Okay.
So those would be the 2 clearest cases. But in the main, these decisions that come out of the courts, frankly, on a daily basis, are important precedent, particularly in areas like this where there's not a lot of them. So, in cases like this where there's only a handful of these kinds of cases, but when they consistently go in one direction, you feel more comfortable predicting the risk and the outcomes of any future case. So we feel more comfortable saying with a higher level of confidence that this particular outcome will follow again, because there really are no outliers to guard against.
And does the judge look at the precedents, like the previous cases, and does that make his job easier? He goes, well, this has been decided 100 times before, and it's exactly the same case. This, instead of me doing all the work, I'm the judge, let's say, I just look at the last 100 cases, they did all the work, and essentially it's a much easier kind of decision for them. It sways them instead of, they're just not looking at these as brand new cases. You're citing all of these previous cases when you do a motion to dismiss.
Correct. Yeah, you'll put these cases in your brief, and it depends on the judge, right? Every judge has a different temperament. Some of them are very busy. Some of them appreciate the value of a settled proposition of law. Others like to take their jurisdiction, very seriously and say, this is the first time I'm looking at the issue. I'm going to evaluate it as though it were, a fresh issue coming to me for the first time. I'll look at these decisions, and maybe they're persuasive, maybe they're not, but I'm going to make my own decision.
So a judge could say, that's great what they did over in New York, but we're in Texas. We do things differently.
Nothing stopping him or her from saying that.
Okay. I've seen that on Law and Order, I think, or something. That's where it came from. Okay. And then I think this is the last question is I've heard also that some of these companies actually want a judge, to hear the case and to throw it out, because then that essentially kind of validates their growth hacking technique or their business process, so that they don't most likely have people thinking this is, a opportunity for them to make a lot of cash. Essentially people go, well, that's been played out. So is that true? Do companies want a ruling on what they're doing?
It's certainly part of the calculation that we consider when we're deciding how to respond to a lawsuit,
okay.
Right? So it's certainly possible to throw some money at the problem and see if it goes away, right? Just a so-called nuisance value settlement. But then other clients, if they're really behind the SMS and MMS platform, they may want to get that good ruling in their back pocket, because it can discourage other plaintiffs' attorneys from filing a similar case in the future. So it can give you a nice weapon in the arsenal of, if you get another demand letter or you get another lawsuit, you've already got one court who's looked at it and found that it doesn't violate the TCPA. And that's valuable to some clients.
Interesting. So it's almost like, let's say a brand gets a bunch of demand letters all the time for similar type things. And then you have to go and, look up the phone number, do a lot of due diligence on your end. You could maybe even take one of those demand letters and say, yeah, let's go to court. And then you could instead, respond to these future demand letters like, no, this has been resolved in court and what we're doing, is fine. So it kind of puts up another brick in that defense wall, for future stuff. I never thought about it that way. It's an interesting kind of tactic, expensive tactic, obviously. But
the motion to dismiss phase may be a relatively good investment if you can get it done then.
Yeah. And
we've definitely had clients that say, you know what, I'm not settling things when I didn't do something wrong.
Yeah. Yeah.
And so plenty of clients just decide on principle that they're going to defend their conduct.
In regards to defense and cost and things of that nature, do you know how long it took between the filing of this lawsuit and when it was thrown out?
From the dates that are on this decision here in the docket number, I'm taking it that it was several months, but probably less than a year, if I had to guess. Okay. Here, I didn't pull this docket, but typically a motion to dismiss gets resolved in under a year. It's, like I said, it's something that you file typically in lieu of an answer to the complaint.
Okay.
So you say, again, we went over this in the beginning. Fine, everything. Let's just pretend like everything you're saying is true. You still lose. And then this particular court is one of the busiest courts in the country, particularly with TCPA cases. So that can obviously extend the time to get a ruling, but you're kind of just in a waiting pattern at that point. So you're not really racking up fees unless they're status conferences. And
what is it, and I know every case is different, but just for those text message marketers out there, to go from, the evaluation, of a lawsuit that you receive for text messaging all the way through to, the motion to dismiss and getting it thrown out. And I bet there's paperwork after that. I know it could take, up to a year. What are we talking in terms of legal cost? And then I'm guessing also there's a lot of other costs, like just employee cost and looking, doing due diligence on the defense side. It's unfortunately not super cheap, to defend yourself. So maybe give me some ideas of what are you looking at here? How big of an issue is this?
Yeah, sure. I mean, it's hard to get out of a lawsuit in under 5 figures. There's going to be at least 2 rounds of briefing, probably going to have a hearing depending on the court. So you're going to be heading out to whatever court it's been filed in. So you've got at least 3 major events, and then to get it dismissed, assuming you win, that's a fairly perfunctory process. But as you said, one thing to consider is the soft time in the form of distraction on the business side, right? Like the IT folks, the marketing folks, they have to marshal all of the evidence that's relevant to this case. The good practice, of course, is to issue a litigation hold notice so that everybody hangs on to the relevant documents. You don't know you're going to win that motion to dismiss, so you want to suspend those kinds of processes that would otherwise cause relevant information to become deleted. So there's definitely a cost to the business of the filing of any lawsuit that is outside of the out-of-pocket spend on legal. But those are essentially unavoidable, because if you lose the evidence and you need it,
worse. Yeah.
Yeah.
Okay. And we always recommend is from the get-go, employing or, consulting TCPA attorneys. And it's interesting. It used to be back in the day, it was only for mass text messaging campaigns. It was like, if you're doing a mass text messaging campaign, go to a TCPA attorney. We're seeing a lot of new cases with kind of like new technology and new use cases where, before, I guess, Glide, no one even thought about sending text messages to invite their friends from within an app that wasn't a text message marketing provider. So I would say at this point, I've been recommending all my friends to do this, is if you have any component of your business that is text messaging, even if customer support, is text messaging, it is worth it to go and talk to a TCPA attorney about what you're planning on doing or what you're currently doing, to see kind of the exposure and maybe to fix some, existing issues.
Yeah. So right. WebRTC, the online widgets, customer support, as you say, and the TCPA rules vary based on how you're communicating, what technology you're using, what you're communicating about. Is it informational? Is it promotional? So there are a number of inflection points that are very important to getting the answer right on a TCPA analysis, and it's probably not something that you want your general business attorney to be focused on, because there's a lot of things to get up to speed on, and some of the nuances can be fairly subtle, and
even your marketing person, your growth hacking person, definitely not. But I see a lot of them, and I'm a little concerned with some of these videos because we do cover a lot of stuff and we go kind of in depth on some of them. This is not to be used as okay, I've learned exactly what I need to do and I'm going to go implement it. I think it's more of a, hey, that's interesting, I never thought about that. Or, oh, shit, we have text messaging, as some, component of our business. Maybe we should, I didn't even know about the TCPA. That's these videos. They're essentially to kind of spur conversations, make sure that when you contact your TCPA attorney, you're asking the right questions. You're telling them, not only are we doing mass text messaging, we also have support. And I didn't even think about telling you that. So hopefully these kind of videos, I know you guys have a bunch of resources on your website. What's the website address?
It's tcpadefenseforce.com.
Okay, tcpadefenseforce.com. They have a great blog. It's always being updated with the newest cases. So if you want to just kind of track what's going on, and then obviously they can contact you. You guys only represent the businesses. So don't contact them if you're interested in suing somebody. Contact them if you're interested in not being sued, or unfortunately, if you are getting threatened to sue or you are being sued. For TCPA stuff, right? You don't handle divorces or anything like that. Okay, so
we started as telecom attorneys, and through that became interested in the TCPA by representing platform providers, and now the practice has expanded to the brands and anybody else on the compliance or defense side of TCPA issues. But no, we've never represented a plaintiff in a TCPA case like this. And now we represent technologists, and
it's cool to focus because you go to, a local counsel or even, inside counsel if you're a large enough company. And yes, they can do research on TCPA, but they're not following it. They're not, really immersed in it like you guys are. Now, I'm guessing if you have inside counsel, a lot of times you at Innovista Law, you guys work with the inside counsel. It's not like you're taking their job from them or bypassing them.
We're allowing them to sleep at night because they don't have to go study all of this, right? And they have other things to worry about. If they're a public company, they have all sorts of SEC issues to worry about, employment issues. Yeah. So this is, one of the various responsibilities they have, and so we certainly work with in-house.
If you're in marketing and you have inside counsel, let's say you're a large enough company, is the normal process, because again, I'm not an attorney, so I don't know how you guys kind of work with each other, is the normal process that the marketing person would go to inside counsel and say, hey, we're interested in text message marketing, and then maybe drop one of these videos in or mention your name and be like, And if you guys are interested in working, these people have been putting out a lot of good resources and kind of dropping your name to them, and then their inside counsel decides if they need you or not. I don't know, how would you best approach that from the marketing person's perspective?
I mean, it happens any number of ways. Either if they have the autonomy and they're allowed to engage outside counsel. Obviously, these kinds of folks can contact us directly. They do. And oftentimes we'll have joint calls with the compliance folks, in-house, legal, and IT. And we just, as I said before, we mock up the campaign architecture so that everybody and all the relevant stakeholders are on board.
Okay. So
we break it off. So we have pieces with in-house, educate them so that they don't feel like they need to babysit the process. And so we can kind of take over for them, report back as needed, and then work directly with the IT and marketing folks to really get the thing off the ground.
Okay. So a bunch of different ways you can slice it, not just one best practice, but I think the best practice is no matter what, make sure you're educating TCPA, make sure you're, employing some kind of competent legal counsel that knows about the TCPA, no matter what text messaging you're doing, which I think is something I just kind of thought about here is there's a lot of companies that approach me for all kinds of weird text messaging stuff, even texting employees. It is not just a concern for mass text messaging. It's a concern for anything because, anything it would fall under the TCPA or can have, can create confusion under the TCPA, I guess you could say.
Sure. And the 8-9 figure exposure that TCPA liability can create is enough to get any in-house counsel's attention. So, it's certainly getting much deserved scrutiny and attention.
Yeah. And so that was a TCPA case review. As you can see, kind of we talk about not only the case, but also kind of almost everything also related to the case, and to make sure that text message marketers know what to do when they're building, when they have been sued. This was the Down to Lunch app, which again is not a Grindr or a Tinder for networking. This is actually like a Down to Lunch, so it's existing friends. I'm sorry. People download it, check it out, and also see. I think go in and see if they're still using text messaging. It'd be interesting to know. It'd be interesting to see, how they're using it, because in a lawsuit, sometimes there's not as much information that, as a marketer, I would like to see. I'm definitely going to download the app and see, do they have the invite all? Do you select the friends? How is the message structured? Because I think you can learn a lot, just again, putting TCPA aside, but the growth hacking techniques, you don't always have to reinvent the wheel. So, all these cases, I always recommend opting into the text messaging, seeing what they're sending, things of that nature. This was Warciak, and again, I bet I'm butchering it, versus Nikil, which is the company that built or developed Down to Lunch app. Again, my name is Derek Johnson with Tatango.com, and Joe Bowser, he is a TCPA attorney from Innovista Law, home of the TCPA Defense Force. And this was another TCPA case review. Thanks, Joe.
Thank you, Derek. Thanks, everybody.
Talk soon, everyone. Bye.
Bye now.